I'm Martha Minow, and it is with great pleasure that I introduce the first of 10 lectures in a series on diversity and U.S. legal history. There is a fabulous lineup, and I will describe briefly each of the 10. This is also part of a reading group that is being led by Professor Mark Tushnet. Mark Tushnet is actually responsible for helping to get this whole thing going. So everybody, thank Mark Tushnet. So I'll come to today's speaker last. The next one in the series is Professor Randall Kennedy here on the faculty. His talk is on the desegregation of medicine. Then on September 21st, Professor John S.W. Park from UC Santa Barbara will speak on coming into an awareness, unlawful children in American law and society. Then on September 28th, and these are all posted and there's a flyer coming around, we will have a visiting professor here, Rachel Moran, former dean of UCLA Law School, talk about liminal Latinos, contested categories, coming challenges. Then on October 3rd, our own Michael Klarman will speak on race in American history. On October 5th, one of the great professors at Harvard University, Diana Eck, will speak on religious pluralism and American law. On October 19th, Catherine Franke from Columbia will speak on reparations. And on October 26th, the amazing Annette Gordon-Reed will speak on law and race-making in early America. And November 2nd, Tomiko Brown-Nagin, who is actually on leave but has agreed to come give a talk, will speak on social movements and social change. And on November 16th, Ken Mack, also on leave, has agreed to speak. So it's a pretty bang-up lineup. It's an amazing group of people. If there's interest, we could continue this series well into the spring. There are many other topics that aren't covered here, but the resources at the law school I think offer a great avenue into thinking and understanding diversity in U.S. legal history. Today, we are very lucky to have Joseph William Singer, who is going to speak on 567 Nations, the history of federal Indian law. It really would be hard to find someone who knows more about this than Professor Singer, who could actually give a multiple-hour lecture on this subject. He's going to give us all of the history of American Indian law in about 45 minutes, which is not going to be possible. So he's going to actually touch on it, but I think if you have any interest in this subject, we have some wonderful visitors this year teaching in this area. But Joseph Singer is one of the executive editors of the leading treatise on American Indian law. He serves also on the group that reviews what briefs should go to appellate courts and the Supreme Court and which ones would not be so good to go in this area. And he's going to talk today about sovereignty and about the fact that we have more than states and more than the federal government in the United States. We actually have Indian tribes, a whole other group of sovereign nations, and their treatment and mistreatment is an important part of the American legal story. Joseph William Singer, I'm not going to take any more time. Everybody can look up his great bio. He's really, really, really great, and the fact that we're married is only one reason I say that.
So I wanted to start by just mentioning a couple of items that you may have seen in the news. The picture here in the upper left is a picture of, if the caption is correct, members of the Standing Rock Sioux tribe, but probably other Indians as well that are protesting a pipeline that's being put through their historic territory. Near their current reservation, not on the current reservation, through another tribe's reservation, but also through private lands. The company has received federal permits from the Corps of Army Engineers and did what they thought. They did all the things they thought were needed to be done. The Sioux are arguing that the pipeline is passing through their sacred lands and that they were never consulted about the effects that that would have on them. Federal law does require consultation with the tribes. Law here is complicated, but this is an ongoing thing. A district court judge issued a temporary restraining order yesterday, halting part of the construction, but allowing part of the construction to continue. To the bottom right, you see the seal of the Mashpee Wampanoag tribe, one of the two tribes here that are recognized by the federal government in Massachusetts. And the Bureau of Indian Affairs put land into what's called trust status for them in Mashpee, which is their homeland on Cape Cod, and also in Taunton, which is a city in southeastern Massachusetts. A federal judge recently ruled that the Secretary of the Interior had no power to do that because a federal statute authorizes this to be done only for tribes recognized after 1934. The head of the BIA contests that. This is my friend Kevin Washburn. He was the head. He's not the head anymore. But he promulgated regulations that were the basis for having the land put in trust status. There's another court case that goes the opposite direction for this. From the standpoint of the Mashpees, they struggled for 50 years to get recognition by the federal government of their inherent sovereignty that they never have ever given up, that they've had from time immemorial. And they're being told now by a federal judge that they cannot exercise their sovereignty in the same way that other tribes can exercise it. Both of these controversies are incredibly complicated in terms of the applicable law and what the law is. I want to give you some background just to understand some things that you need to know to even get up to the first level of actually having some sense about what's going on in these situations. And what it looks like from the standpoint of the federal law, but also what it looks like from the standpoint of the tribes. First thing I just want to emphasize is from the title of my talk. There are 567 Indian nations currently recognized by the federal government. There are more tribes that are not recognized by the federal government. Some are recognized by the state governments. These nations pre-exist the United States. They were here before the colonists came. They're here today, and they will be here tomorrow. The United States dispossessed Indian inhabitants of most of the land in the country, and it's exercised sovereign power over them. There's no polite word for this. The United States is a democracy, but the United States also has engaged in imperialism and conquest. At the same time, it's absolutely crucial to realize and to understand that conquest was incomplete. The tribes had political sovereignty before the United States was established, and that sovereignty persists today, and it is recognized by federal law. The United States is comprised not only of the states and the federal governments, but the tribal governments. They are a third set of sovereigns. More than 200 of them are in Alaska, and about 200 are in the continental United States. They are incredibly diverse. They have different languages, different religions, different customs. They each have their own constitution. Some of them don't have a written constitution. They have tribal codes. They have police. They have colleges. They have businesses. They are organized quite differently in terms of politics. They're really quite diverse. And the recognized tribes have a government-to-government relationship with the United States. Federal policy toward Indian nations has flipped 180 degrees many times in U.S. history. And I want to just give you a sense today about how that happened. Sometimes the United States has respected tribal sovereignty. Sometimes it's taken steps to limit or even destroy it entirely. Current policy both supports tribal sovereignty and also limits it substantially. I'm looking up because I'm not a great PowerPoint user. I don't sort of trust what's here in front of me. So anyway, before 1776, the colonial powers competed to control territory in the Americas. They wanted to settle, and much for them was a new world. That required the displacement and conquest of the native nations that they found here. Within the 13 American colonies, the colonial governments competed with King George to control relations with the Indians. The colonists did a really, really bad job of managing these relationships. They often encroached on tribal lands without the consent of the tribal leadership or members of the tribes. They engaged in a variety of actions that led to skirmishes and violent clashes. To stop this, the king in England, King George, issued the Proclamation of 1763. He set a border along the Appalachian Mountains, and he said nobody can go into that territory without a permit. He took charge of all transfers of land from Indian nations. The idea was that there would be no permanent transfers of land title from the Indian nations to anyone except to the King of England in procedures that would be superintended by these royal superintendents. He wanted to create a centralized process to acquire the lands. He obviously wanted the lands, but he also wanted to avoid war. When the colonists declared independence in 1776, they adopted the Articles of Confederation. It was drafted in 1777, but not fully ratified to 1781. I think that con law teachers here don't tend to talk about this very much because it's before the Constitution and we sort of got rid of it. It's important in this area, and I'll explain why. The drafters of the Articles of Confederation simply could not agree on who would be managing relations with Indian nations. On the one hand, they gave Congress the sole and exclusive power of regulating the trade and managing all the affairs of the Indians. But the Articles also said that the states could regulate Indians who were members of the states. And it also said that the legislative right of any state within its own limits would not be infringed. The 42nd of the Federalist Papers, number 44, James Madison made fun of this. It's really one of the funniest of the Federalist Papers. So this gives 100% of the power to the Congress while reserving some power for the states. And he said this is a mathematical impossibility, right? To have 100% in someone and 20% in someone else. What it actually meant was the states and the federal government were fighting over who was going to control Indian affairs. And the drafters simply couldn't agree about this. Same thing as in colonial times, the states did a terrible job of this. They were seizing land without the consent of the tribes. There were settlers that were invading tribal land, creating, again, clashes. Federal government tried to manage relations with the Indians, but they could not do so effectively because federal promises were violated by state governments. After the War for Independence, Great Britain negotiated with the United States, and the U.S. and Great Britain signed the Treaty of Paris in 1783. Most of the tribes sided with the British because the French were better for the Indians than the British, and the British were better for the Indians than the Americans. The Americans were by far the worst in terms of Indian relations. Most of the tribes either fought against the United States or were neutral. The Oneida Indian Nation was one of the allies of the United States. I think the Tuscaroras also were an ally. Almost all the other tribes were either neutral or hostile to the United States. Great Britain had tried to become allies with a lot of the tribes to have them fight on behalf of Great Britain. And in the Treaty of Paris, Great Britain abandoned them. It made no provision in the treaty whatsoever for the Indian nations. At that point, the United States treated them as conquered peoples, or they tried to. In reality, the United States had not conquered the Indian nations, but the U.S. tried to enact a conquest policy. The U.S. negotiated 3 or 4 treaties with tribes in the Ohio Valley. They found a few people, and they got them to sign these treaties. Most of the people in the tribes didn't agree with those treaties. The United States started trying to enforce them. They had a bunch of land being given up. And the tribes were furious at the United States. They started banding together, and there was a possibility of an all-out war with the Indian nations in the Ohio Valley. U.S. obviously didn't want this. The U.S. couldn't afford it and didn't want it. George Washington and Henry Knox got the U.S. to change its policy. The U.S. renegotiated those treaties. Instead of treaties of surrender, the treaties treated the Indian nations as sovereigns with sovereignty over their land and title to their lands. And in those treaties, the tribes gave some property to the United States, reserved the rest, and didn't say, we've been conquered and you've sort of taken us over. That's where the term reservation comes from, that most of the lands are reserved. Most of the treaties are tribes giving property to the United States and not the United States giving property to the tribes. There are some treaties and statutes where the U.S. does give property to the tribes. 1787, Congress passes the Northwest Ordinance. It's very similar to the proclamation of 1763. No one can go into the Ohio Valley, Northwest Territory without the consent of Congress. No transfers of property without the consent of the United States. We then get the U.S. Constitution. Because the Articles of Confederation had simply not settled the issue of whether the states or the federal government would govern Indian affairs, one of the main purposes of the Constitution, in my opinion, was to settle this question. Those two exceptions about members of the states and legislative jurisdiction were written out. And there were various drafts of this. Eventually, they just made this part of the Commerce Clause. And there's something called the Interstate Commerce Clause. This is the Indian Commerce Clause. And it says the Constitution gives Congress the power to regulate commerce with the Indian tribes. This was later interpreted to say that this preempts all state authority over Indian nations. That's not completely the law today, but that's what it was for a while. One of the first statutes Congress ever passed was the Trade and Intercourse Act of 1790, also called the Non-Intercourse Act, part of which is still in effect today. It prohibited non-Indians from entering Indian country without a federal permit, and it regulated trade with the Indians to make sure they wouldn't be cheated. It also prohibited any transfer of lands in fee simple from Indian nations to any person without the consent of Congress or consent of the United States. It's worded that it has to be in a treaty. And it's kind of a complicated thing because the tribes are allowed to transfer property under tribal law. If you were able to get into tribal territory, you could get whatever rights they would give you under tribal law, but you wouldn't get fee simple title. And what's fee simple title? Fee simple title would mean that you can be easily passed from hand to hand, could be mortgaged. And at this period, what that also would have meant is you would have been subject to state law rather than tribal law. And so one of the purposes of the Non-Intercourse Act is to say we actually don't want non-Indians getting title from the tribes unless the United States manages it. Again, because the states were doing a very bad job of managing these affairs. This statute, the Non-Intercourse Act, was ignored by several states. The worst ones were New York and Georgia. New York just, it's hard for us to remember what this might have been like back then in 1790. This is a federal statute. The Constitution says it's the supreme law of the land. Governor Clinton, not this Clinton, but a different Clinton, just ignored it. He just had state treaties with a bunch of tribes in New York and just took a bunch of their land. And we are still today fighting about the ownership of those lands. In this early period, the U.S. Supreme Court decided several cases that I have up here: Jones versus McIntosh, Cherokee Nation, Worcester versus Georgia. This is referred to as the Marshall Trilogy after Chief Justice John Marshall. I'm going to give you my interpretation of what I think these cases say. I think they are misinterpreted by a lot of people, including, I have to say, by a lot of property law professors. The Jones versus McIntosh is a lot of the property case books. I know some of you may have read this already. My interpretation is somewhat different than what I think a lot of other professors say, and I'm giving you my interpretation. The holding of Johnson was that the tribes have title to their lands and sovereignty over it, but that the doctrine of discovery gives the United States part of the title as well. If you read the whole opinion, you see that it talks about the Indian title of occupancy, and it says the U.S. has title also, absolute, ultimate, absolute. The U.S. has title in fee. It doesn't say fee simple, it says in fee. But it does say Indian title. So the title is split in some form between the United States and Indian nations. The holding of the case, Johnson versus McIntosh, is that Indian nations cannot transfer title in fee simple directly to non-Indian citizens without the consent of the United States. The case suggests that any transfers that would happen by acquisition. There's a use of the word preemption, preemptive right. The later cases, Cherokee Nation and especially Worcester, interpret what acquisition means. And if you look at these three cases together, what they actually say is that the United States is going to acquire title through negotiated treaties, not through force. That's the way I understand the structure of what Chief Justice Marsh was trying to do. He recognizes the reality of conquest in the opinion. I think a lot of people misread sentences in the opinion to say conquest happened, it was great, and what can we do about it? The opinion doesn't say that at all. It says conquest happened. Marshall shows discomfort with conquest. I think he was trying to put a brake on future conquest. Obviously, they thought that the United States would acquire Indian lands. They thought this would happen. They thought it would happen naturally. But they wanted it to happen through negotiations and sales rather than through military conquest. Cherokee Nation versus Georgia. In this case, in the 1820s, Georgia passed a law abolishing the Cherokee government, which the Cherokee land was within the Georgia borders. Cherokee Nation sued the state of Georgia to get basically a declaratory judgment that this was an unconstitutional or illegal law. And they sued on a basis in the Constitution that says foreign nations can sue states in the Supreme Court. The Supreme Court said they are a nation. The Cherokee Nation is a nation, but it's not a foreign nation. It's a domestic, dependent nation. This is odd. There's nothing else in our system that looks like this. Very hard to know exactly what it means. The meaning changes over time. My summary of this is the Supreme Court saw the Cherokee Nation as domestic rather than foreign because it's located within the geographic borders of the United States. Any attack on the Cherokee territory would be thought of as an attack on the United States, for example. It's dependent. I think what this came to mean was if there's any conflict between Cherokee law and United States law wins. Right? The United States is supreme and has some kind of power over the Cherokee tribe. It's a nation because it retains its inherent sovereignty that it had before the United States was established. So the word nation is not something that liberals invented in the 1960s. It's not, there were a lot of Indian activists in the 1960s. It's not a sort of recent thing. This is the word used in law in the United States. We use the word tribes also. But the legal system classifies the tribes as nations with sovereignty. Worcester versus Georgia, 1832. So the lawsuit was Cherokee Nation versus Georgia was thrown out because there's no jurisdiction in the Supreme Court. Two ministers entered Cherokee country without the permits that are required under Cherokee law, and they're charged with criminal trespass, among other things. They finally got the case in the Supreme Court. Supreme Court invalidates the Georgia law and says Georgia law has no force in Cherokee territory. Even though the Cherokee territory is within the borders of the state of Georgia. The quotation here, Cherokee Nation is a distinct community occupying its own territory with boundaries accurately described in which the laws of Georgia can have no force. Result of this is we get some principles from these cases that are still part of federal Indian law today. First one is that Indian nations are sovereigns. They have inherent sovereignty. Sovereignty is not derived from the federal government. They also have title to their lands. Second, the tribes govern their own lands, but they're not allowed to transfer title in fee simple to anyone without the consent of the United States. Third, in general, the states have no power over Indian nations unless Congress delegates such power to the states. This has been changed by the Supreme Court in the last 50 years a little bit, and I'll explain that a little bit later. And finally, the United States has power of Indian nations. What kind of power is actually somewhat contested. There are parts of U.S. history where the power is said to be absolute. There are others where tribes have constitutional rights. And then I just have to say, if you look at this from the standpoint of the Indian nations themselves, the fact that the Supreme Court and the Congress say that they have absolute power over Indian nations doesn't mean the Indian nations agree that they have absolute power over Indian nations. They can say it, but it doesn't mean the Indians have to accept it. Rest of the 19th century is just kind of, painful to talk about. 1835 to 1861, we have what's called the removal era. Andrew Jackson was elected president of the United States. I was actually, hoping he'd be kicked off the $20 bill, but it didn't happen. Congress passed a statute in 1830 called the Indian Removal Act. This was supposed to be voluntary removal of tribes to west of the Mississippi River. Part of what's Oklahoma now was called Indian Territory. They were trying to get the tribes to move there. The statute provided for voluntary removal. Jackson ignored that part of the statute, and he forced most of the tribes in the South and the Northwest Territory to move to Oklahoma. A bunch of people stayed. There are some tribes in the eastern part of the United States or people that just refused to go. The Cherokee Nation was forced to move in 1832. It's called the Trail of Tears. This forced march of the entire nation caused the deaths of 4,000 people. This was 1/4 of the Cherokee Nation. To get a sense of what this is like, imagine the population of California, population of New York, and the population of Florida. California, New York, and Florida together are about 24% of the population of the United States. Imagine every single person dying. The policy in this period was based on the idea that the Indians could not be assimilated into American society. They had to be separated from the United States. This is one version, one can say, of the origin of the separate but equal doctrine. It was applied to Indians before it was applied to African Americans. After the Civil War, the United States acquired as much territory as it could. It got most of the territory in the West. There were a lot of horrible, horrible wars in this period. At least 6 major wars with the Sioux tribe. Most of the territory was acquired by the tribes through war and coercion. At the same time, I do think it's important for us to remember that most of the territory was acquired through treaties. And the treaties had promises that were given to the tribes in exchange for the land. There was money that was given. But a lot of the treaties also had promises of social services, including housing, education, medical care, and food in exchange for those lands. There were treaties negotiated with the tribes in California. The Senate never ratified them. So the tribes in California have no treaties. The tribes in Massachusetts have no treaties. So sort of early and late tribes had no treaties. There are statutes governing this area of law. But there are no treaty promises to anyone in California because there are no ratified treaties. At the end of the 19th century, the Indian population had diminished in something that just resembles genocide. So imagine the population of the United States being reduced to the population of Boston. It's roughly on that horrible set of numbers that you can imagine. The population was just unbelievably reduced by the end of the 19th century. Congress passed a statute in 1871 saying no more treaties will be signed with Indian nations. We're not going to treat them, in a sense, like nations anymore. The statute, by the way, I think is completely unconstitutional. But anyway, there it is. The United States adopted a policy at the end of the 19th century from 1870 or so afterwards to destroy tribal government, to force Indians to convert to Christianity, eradicate their culture, and integrate them into American life to the extent possible. Courts of Indian Offenses were created in 1883. Their main job was to suppress tribal religion and to criminally punish people for practicing tribal religion. Indian children were forcibly removed from their families and sent to boarding schools and indoctrinated in non-Indian ways. The boys had their hair cut. They were punished for speaking tribal languages, plus being forcibly removed from their parents. And the United States tried to inculcate private property norms in the tribes in this period. They thought that tribes were not selfish enough. They had to teach them to be self-interested and to be focused on money. And the vehicle for doing this was the General Allotment Act of 1887. The property of the tribes was taken away from them without their consent and without any compensation, and it was transferred to individual members of the tribes. Those interests were called allotments. They picked a certain number of acres that everyone would get. The lands that were left over were called surplus lands, as if the tribes didn't need them. Those lands were sold to non-Indians. So we get, at this period, for the first time in history, you have non-Indians owning land in fee simple within reservation borders. And we still have that today. So that happened in this particular period. 90 million acres of land were lost, 2/3 of the tribal land. Again, if you just imagine all of the land west of the Mississippi River being lost to the United States. Again, roughly sort of on that scale of loss of property. In this period, you get the Supreme Court deciding a whole bunch of cases, and they all sort of amount to one thing, which is that the United States has absolute power over the Indian nations. Their sovereignty exists at the sufferance of the United States. It can be completely abolished. And tribes have no constitutional rights whatsoever. It's sort of the flavor of these particular cases. The case of Ex parte Crow Dog in 1883 involved one Indian murdering another. From the beginning of the Republic, starting around 1817 or so, there had been federal statutes that allowed federal prosecution of crimes involving Indians and non-Indians. This was Indian versus Indian, and there was no federal prosecution of those crimes. Those were done by the tribes themselves. So this particular situation, the tribe, used its procedures, and there was a religious ceremony, and there was a healing ceremony, and there was reconciliation in the tribe. There was no execution, and there was no jail. The non-Indians were completely outraged. They thought this was barbaric, because civilized people execute murderers, right? And the tribes were so barbaric, they had no law. So in order to protect the tribes from their own barbarism, Congress passed the Major Crimes Act in 1885, which provided for federal prosecution of major crimes like murder and rape and burglary and several other crimes. The Supreme Court had to figure out, is this constitutional? Where's the source of power for this? So you learn that the federal government is a government of limited powers. So there has to be some source in the Constitution that gives Congress the power to pass this law. There is no text in the Constitution that gives Congress the power to pass this statute. The only text we have is the Commerce Clause. Murder is not commerce. And amazingly, the Supreme Court in U.S. versus Cogam in 1886 said murder is not commerce. So the Supreme Court said the Commerce Clause is not the source of power for Congress to pass the Major Crimes Act, which provides for federal prosecution of murders of one Indian by another. Nonetheless, the United States had the power. There's no textual source for it whatsoever, right? So when you learn in common law classes that you need a textual source for power, you don't need it. Right, apparently here. Also, I think immigration, you don't need it. So there may be others as well. But there's absolutely no textual source. Supreme Court in the recent years, meaning about 30 years ago, they started getting embarrassed that there was no textual source. So now they say the textual source is the Indian Commerce Clause. So you're going to learn about the cases that interpret the Interstate Commerce Clause and say commerce means commerce. And so you can't criminalize the possession of a gun near a school, because that's not commerce. And there are cases that kind of, say, well, the Commerce Clause is limited to commerce, but the Indian Commerce Clause is not limited to commerce. Why? Let Professor Tushnet explain it. There's no reason that they give for this. They just say, well, somehow, I don't know, it's different. 1903, Lone Wolf versus Hitchcock. Congressional powers extended even further. Remember I talked about the Standing Rock Sioux at the beginning. There was a treaty with the Sioux tribe that said no further seizures of Sioux land without a vote of 3/4 of the adult males. The United States broke that promise, and the Sioux sued and said, you don't have a power to take our land because we never agreed to give you the power to take our land. We didn't sign the Constitution. We associate ourselves through the treaty. You promised not to take any more of our land. Congress did it anyway, and the Supreme Court said that was completely fine. The Lone Wolf case effectively says that these are political questions, not justiciable, and that Indian tribes have no constitutionally protected rights whatsoever. No right to compensation for the lands, no right to have their lands taken only with their consent, no protection from any federal statute whatsoever. Matthew Quay was the senator in Pennsylvania at that time, in 1903. His reaction to this was, Lone Wolf is the Dred Scott decision number 2, except in this case the victim is red instead of black. The decision practically inculcates the doctrine that the red man has no rights which the white man is bound to respect, and that no treaty or contract made with him is binding. This case has been partially overruled. If tribal property is recognized by treaty or statute, then it will be given some constitutional protection. There seems to be no constitutional limits on the power of the United States to end its government-to-government relationship with tribes, however. There's some language in Morton versus Moncari, a late 20th century opinion that says Congress's actions toward Indians had to be rationally tied to Congress's unique obligation to the Indians. There's never been an act of Congress struck down as unconstitutional under that framing. It's important to know that all Indians were made citizens of the United States by statute in 1924. This didn't alter their relations with their own tribes, but it also didn't make them citizens of the states. And there were a fair number of states that didn't allow Indians to vote in state elections until the 1960s. This is a very recent change in the law, actually. So we have this period where the United States is actually trying to destroy tribal sovereignty and culture. And then remarkably, in 1934, there's a 180-degree turn. They go completely the opposite way. The idea now is that was a disaster. We want to revitalize tribal government. We want to revitalize tribal culture. We want to have tribes engage in business. So they passed the Indian Reorganization Act. And the idea is to have the tribes adopt constitutions. And most of the tribes did. Some of them did not, like the Navajo did not adopt one of these constitutions because there were a series of constitutions that were suggested. And all of them were not similar to the Navajo governmental process. So the Navajo have a constitution, but it's not one of these IRA constitutions. But a lot of tribes did adopt constitutions. Because they were made subject to this federal model, a lot of them were inappropriate for the tribes. They were not fitting the tribe's culture or traditions. Many, many tribes now have rewritten their constitutions to make them closer to what they either traditional ways of governance or traditional values. But there was this period where the United States was actually trying to revitalize tribal government and culture and say, we actually don't want the tribal governments to go away. This was a short-lived policy because in the late 1940s and 50s, we flipped 180 degrees again. The United States said, we actually think the tribe shouldn't exist. We want to end tribal government. We want to assimilate Indians. We want them to move to the cities. No longer are we going to try and make them farmers. We're going to make them workers in the city. There were about 100 very small tribes that lost their government-to-government relations with the United States. There were two big ones, Klamaths and the Menominees. They were both restored to government-to-government relations with the U.S. Later on. 1955, 1 year after the decision on Brown versus Board of Education, we get the decision Teton Indians versus the United States. Some of you I know will read this in your property class. This involved a band of the Tlingit Indians in southeastern Alaska. The United States took timber from their lands without compensation and without their consent. And they said, it's our property, you have to compensate. The Fifth Amendment says no taking of private property without just compensation. The Teutons actually do own the timber, and they did own it back then. They owned it under tribal law. They owned it under federal common law. But apparently, they don't have property within the meaning of the Fifth Amendment. Supreme Court said, if there's a treaty or statute by the Congress recognizing their property, then they have constitutionally protected property. If the Congress hasn't acted to protect their property, then they have no constitutionally protected property. This case is still the law. And it still matters because there's some tribes, like the Spokane tribe. Some of you are going to do a problem in the problem-solving class in January involving negotiation with the Spokane tribe. Their reservation was created by executive order of the president. They don't have a treaty. They don't have a statute. Under current law, the United States could take their property with no compensation. This is a ridiculous case. The reasoning is ridiculous. I teach it in my property class. It's one of the few things where I'm like totally unobjective about it because I can't come up with any argument in favor of it. It's just a ridiculous opinion, in my opinion. I'm getting to the end here. I'll try and finish the next 5 minutes. Remarkably, since 1961 or 1970, I'd say, we're in an era called self-determination. There's this weird agreement between Republicans and Democrats in favor of tribal sovereignty. If you look at the party platforms, they both support tribal sovereignty. They both support a government-to-government relationship between the tribes and the United States. It's really quite remarkable. And the last 50 years has seen an amazing revitalization of Indian nations. There are now tribal colleges run by tribes. There are tribal businesses. In the year 1960, I don't know exactly, but there were probably fewer than half a dozen American Indians who had gone to law school. Right? There were like almost no Indian lawyers at all in the entire United States of America. There are now thousands and thousands of people who've gone to law school, business school. And in this period, the United States has a government-to-government relationship with these federally recognized tribes. The Education Assistance Act, the Indian Self-Determination Act in 1975, a lot of services provided by the federal government to Indian tribes. Under this statute, the tribes can take over these services themselves. Rather than having federal officials provide the services, the tribes can contract, provide the services for their own citizens themselves. Indian Civil Rights Act 1968 assumes there's going to be tribal sovereignty. The Bill of Rights applies only to the federal government. 14th Amendment applies much of the Bill of Rights to the states. Neither one applies to the tribes. The Indian Civil Rights Act of 1968 applies most of the Bill of Rights, not all of it, to the tribal governments. It limits tribal sovereignty, but it also recognizes it as existing. And it significantly limits tribal criminal jurisdiction. Violence Against Women Act was reauthorized recently, and it gives some tribes, not very many, but some tribes, criminal jurisdiction over non-Indian men who engage in domestic violence of Indian women. This happened because there was basically no law enforcement. The federal government was responsible in most cases for enforcing the law, and it simply wasn't doing it. And the tribal police had no power, and the states had no jurisdiction. So you have Indian women who were being abused and the victims of criminal penalties, and there was basically no law enforcement. This is still the case in a lot of situations. The VAWA reauthorization is a great victory. but it requires a level of resources that most tribes don't have. A couple of things I want to say just about the Supreme Court, and then I'll finish up. The Supreme Court has been incredibly active in federal Indian law since 1978. It says that the tribes have no criminal jurisdiction over non-Indians at all, not even for traffic citations, 0. That's what Oliphant versus Comas Tribe says. VAWA restores a little bit of criminal jurisdiction, but a really, really little bit. There's generally federal prosecution in most states. There's state prosecution in a few states. This is something that a lot of tribes are very, I think, legitimately angry about. The federal government is not adequately protecting people from crime, and it's not actually letting the tribes exercise jurisdiction that I think would be needed to actually adequately protect their people. Civil jurisdiction, Montana versus the United States in 1981, the Supreme Court said tribes cannot exercise civil jurisdiction. They can't regulate the conduct of non-Indians on land owned by non-Indians in fee simple within reservation borders. There's some exceptions to this, but the basic rule now is the tribes cannot regulate non-Indians. So think about zoning. If you were in a checkerboard reservation, there's lots of non-Indians that own property, and it's Indian, non-Indian, Indian, non-Indian, Indian, non-Indian. What do you do about zoning law? The tribe can zone the Indians, and the county or the city can zone the non-Indians. That's not actually how zoning law works. They have to come to a little treaty between them to actually have zoning law now. The Marion case says, in general, that tribes can regulate the behavior of non-Indians if they enter tribal land. So we have this kind of tribal land, non-tribal land distinction. But then we have the Dollar General case that was decided in June of this year by a 4-4 vote of the Supreme Court. Right? So this case involves a company, Dollar General, that leased land from the Mississippi Choctaw Tribe. Tribe is the landlord, and the non-Indian corporation is the tenant. So they have this store on land owned by the tribe within reservation borders. Store manager agrees to take some tribal kids as interns and then sexually abuses one of them. So it's a child. It was a child that was abused. That constitutes rape, right? So there is no federal prosecution. We don't know why, but the federal authorities don't prosecute. The state has no criminal jurisdiction. Under Oliphant, the tribe has no criminal jurisdiction, so there's no prosecution of the crime. The family sued the guy that committed the rape and the store in tribal court, Mississippi Choctaw Court. And then, because the family sued the Dollar General Corporation in tribal court, the corporation sues the tribe in federal court and says the tribal court has no jurisdiction over the case. You can't make us go into tribal court to have them issue a judgment for civil damages against us. They lose in the trial court. Trial court says, yes, the tribal court does have jurisdiction. That is affirmed. The Fifth Circuit, by 2-to-1 vote, says, yes, the tribal court has jurisdiction. If you go into tribal land and injure a tribal member, especially a child, you shouldn't be surprised they're going to haul you into tribal court for damages. Goes up to the Supreme Court. They affirm by 4-4 vote with no opinion. 4-4, right? So the future of this type of issue is going to be decided by the presidential election, I think, right? So we don't know anything about the reasoning. Why did 4 of them say there was no jurisdiction? In my opinion, they'd have to partially overrule the Marion case that I just told you about. I'm sure they wouldn't overrule because the Supreme Court never overrules anything, but they would somehow come some way of distinguishing it that I think would. So we don't quite know what they're thinking about this. 4-4 about this. So I just want to end by a few maps, because I like maps. This is a map that most American kids see in their history textbooks. Shows the border of the United States going to Mississippi River, 1783. Why is it 1783? That's the Treaty of Paris. But as I told you, in 1783, that was not empty territory. There were Indian nations living there. That was not empty. Makes it look like 1783, the U.S. got all that land. We didn't get any land. The Indians had the land, right? All we got was a promise by Great Britain not to stop us if we wanted to get the land, right? This makes it look like we got the land. We got nothing. Louisiana purchased 1803. Looks like we got the land. It's called purchase, right? We purchased it from Louisiana. Louisiana didn't own it, right? It looks like, by 1803, the U.S. has a lot of territory. We had almost no territory by 1803, right? Here's another map that is less well known. This is a map of the Indian land cessions. This is a summary of the transactions by which the tribes transferred land to the United States through treaties or through statutes. Very different map from the other one, and the timing is quite different. I was complaining about this for years, and our daughter, as she was growing up, heard me saying, I wish someone smart would figure out how to show that the Louisiana Purchase wasn't empty. And she kind of said, well, what are you trying to do, Daddy? And I'm like, I want to show that there were people living there. It wasn't empty. And she said, well, do you have a map of where the people were? And I said, well, yeah, I sort of have a map of where the people were. And she said, why don't you put that map on top of the other map? And I said, whoa, I never thought of that, but I can't do that. I don't know how to do that. And our daughter uses Adobe Photoshop, and she was a young teenager at the time. And she said, oh, Dad, that's easy. So here's the map our daughter made, which shows the Louisiana Purchase filled with Indian nations. These territories were not empty. They were filled with these Indian nations. And this is a map of Indian country today. So again, if you see a map of the United States, most maps of the United States leave this off. They show you the states. They don't show you the areas where the Indian nations not only have sovereignty, but also have some power over their own people, over their territories. I just want to mention there's a conference October 13th and 14th on indigenous rights that's going to take place here at the law school. And so if you're interested, you should look that up on the calendar. Bob Anderson from the University of Washington is teaching American Indian law in the winter term. And he's brilliant and incredibly knowledgeable. And I just wanted to make sure you knew about those things. So I did the best I could. There's 5 minutes left, but thanks.